Will I lose my house if I need Medicaid?
The short answer to that question is no. Let's break it down into a couple parts. First of all, husband and wife. If one spouse is in a nursing home, the other spouse can claim that community spouse's house, home, the principal residence, as exempt. There is a limit. The limit is $750,000. So if the house is more than $750,000, then there may be an issue. But we have very, very few homes here in central Wisconsin that have a value in excess of $750,000. So the short answer for the community spouse is no, you won't lose your house. That doesn't mean that we don't have to do some planning about the house, because the fact is that Wisconsin has enacted some provisions in the statutes that allow the Department of Health Services to come after the house as part of the surviving spouse's estate after the surviving spouse passes away, which could be 5 or 10 or 20, 25 years later. So we still have to do some planning to protect that house, but as long as the community spouse is alive, the house is protected and social services cannot put a lien against it. Now, for single persons, the rules are different. If you're a single person, the house may be made temporarily unavailable, and you would do that by perhaps listing the house for sale with a broker. If you do that, then the house is not going to be a problem in terms of the medical assistance application. It's unavailable, it's not counted, and so if you otherwise qualify, then the house won't be a problem. However, at some point the house will be sold, and when it is sold, the proceeds then would go to pay for that cost of care, which would mean if the house is sold while that person is still in a nursing home, then they would have more assets than what they would be entitled to under the exemption requirements. And so then they would have to go off of medical assistance until those assets were used up.